Hello everybody, this is Robert Mansour. I'm a lawyer in the Los Angeles area, and one of my areas of practice is estate planning. And so clients come to my office and we create an estate plan, and if you are a client of mine, you know that an estate plan is a legal toolbox. And in this toolbox you have many tools like a living trust, a will, powers of attorney, health care directives, etc., etc. Well, during my final meeting with my clients, I give them a lot of information about how to use their estate plan, what to do, what not to do. And I've noticed that even though I provide them with all this information and I give them specific written instructions, sometimes they return home and they forget a few things. So I created this video to review basically the same information that I review with my clients during that closing meeting. And this is helpful information. Hopefully you'll find it helpful with respect to what to do when you have an estate plan. And that's why I call this presentation, I have an estate plan, now what? So the first question that people usually tell me is they say, look, I don't want to read all these documents. It's just too much to go through. What should I do? What other options do I have? So I tell them in their binder that I give them, in your binder, you'll find an overview section at the very beginning. It'll have a little tab that says Overview. Check out that tab, and that overview section shows you a summary of all the documents in your binder, what they're supposed to do. There is a list of things to do also after somebody dies, so that there's a nice little checklist in case your trustees need to review that. The first few pages of your overview binder are probably the most important, so check those out from time to time. Also, watch this video from time to time. It might be a nice refresher. It's found at my website, which is www.mansourlaw.com/clients. This page of the website is not currently available from the regular menu, so you have to type it in exactly the way it appears. And this web address should also be in your binder as well, on the very first page of the overview section. Another important issue is that you need to make sure you keep Schedule A current. So you have this estate plan and you have a living trust. Now, near the end of your living trust, at least in my estate planning binder, is something called Schedule A. Usually it's the last document in your living trust section. And what this schedule is all about is a list of all of the assets that are in the living trust. So any assets titled in the name of your family trust or your living trust should be listed there. There's two reasons for that. Number one is a practical reason. The practical reason is that if your trustees pick up your binder, they don't have to wonder, gee, what did so-and-so have in their trust? What was a trust asset? What was in the... And so it's all right there for them. It makes life easier. The legal reason for it is the following. If there is an asset that was mistakenly not put in the name of your trust, but it was listed on your Schedule A, in other words, you listed the asset, but you didn't take the time, or something happened where the asset was not actually in the name of the trust upon your death. If you had listed it on your Schedule A, I can go to court, and in most cases, in one court hearing, I can get the judge to put the asset in the trust, so long as I can convince a judge that it was your intention to do so. And one of the ways that I do that is by showing the judge that you had listed it on your schedule. So the point of this slide is to make sure that you keep that schedule current as the years go on. One of the reasons that trusts kind of get messed up is that 5-10 years later, clients have all these other assets, and they didn't bother putting them in their trust, and they also didn't bother listing them on Schedule A in their estate plan. Another question that often comes up that people ask me is they say, look, what if I want to leave certain things to certain people? What if I want to leave certain items of personal property to certain people? Now, in California, there's a couple of ways to do this. There are actually several ways to do this, but the two main ones is to incorporate the gifts in your trust itself. So in your trust, you would have a section that has all the gifts, like I give Johnny my bicycle, I give Sally my motor vehicles, I give all of my jewelry to my sister Nora, for example. Well, in California, you're allowed to refer to an external document. So near the end of your trust, I've given you several sheets called Instructions for Distribution of Personal Property. And you'll see here it says found near the end of the Living Trust section. And that's where you can write down with specificity who gets what. So you can't just say my vase goes to my son Sam. It has to say my vase that is blue that I bought in the Bahamas and have in my living room. And you may even want to take a picture of it and put it right there and print it out and put it right there so it's very clear what you intend. So you see the difference between my vase versus which vase exactly are you talking about. And by the way, probate court is full of people fighting about things like that. You know, grandma promised me this vase. Mom promised me I would get her car. Mom promised me I would get her jewelry. Whatever the case may be. So be very clear about it. Remember, you must put assets in your trust. This is critical. This is one of the primary reasons living trusts fail, is that people get this fancy binder, they get these fancy documents, and they don't understand how to use them. You have to put assets in your trust in order for those assets to be governed by your trust. So if an asset, let's say you create the Smith Family Trust, and you do not take the time to change title to your assets, you do not take the time to put the bank accounts in your trust, etc., and your real estate in the name of your trust, well, then they're not governed by your trust. And here's the thing, you can't just think about it. You can't just go home and put your estate plan under your pillow at night and just have pleasant dreams about your assets floating into your trust. It doesn't happen. It takes effort. So you have to actually get over to the bank and put your assets in the trust. So what goes in the trust? Common assets that go in the trust include checking accounts, savings accounts, CDs, also called certificates of deposit, investment accounts, just regular plain vanilla investment accounts consisting of mutual funds, stocks, bonds, whatever. Any individual stocks, bonds, credit union accounts, real estate, etc. Those things go in the name of your trust. And the question here at the very bottom is, why should I put assets in my trust? Isn't it enough that they are listed on my Schedule A? And a lot of clients make this mistake. They think the asset is in their trust because they listed it, or one of the documents in the binder makes reference to the asset. And they show me, they say, look, it says right here, my checking account is in my trust. I say, no, that's your Schedule A. That's something different. You actually have to get yourself to the bank and sit down with a banker and take some time to put all of your assets in the trust. So once again, the fact that it's listed on the Schedule A that we just talked about does not mean that the asset is actually in your trust unless you take the time to do so. Now, if you have real estate, during the signing meeting with my office, we usually take care of all your real estate. And then you're on your own with respect to all of your bank accounts, and we'll give you a letter that shows the bank exactly how title should read to your assets. And you can take that to the bank and have them assist you with that, or give it to your broker or your financial advisor. So the question becomes, well, how do I put assets in my trust? How do I do this? It's not terribly complicated. You have to use special language. So you have to actually refer to your trust. So here's an example. Let's say Joe Smith created an estate plan with me and has a living trust. Joe Smith would go to the bank and ask that his assets be titled as follows: Joe Smith, trustee of the Joe Smith trustee of the Joe Smith Trust, dated March 14, 2011. If Joe was married and him and Mary came to my office, it would say something like Joe Smith and Mary Smith, trustees of the Smith Family Trust, dated March 14, 2011. They actually changed the title on their accounts. Now, some clients do worry. They say, well, what about my checking accounts? Do I have to put that in the top left of my checks? Do I have to put the Smith Family Trust? And the answer is no. You can put whatever you want. The bank will generally let you put just your name and your address at the top left of your check if you don't want it to make any reference to your living trust. When you go to the bank or you talk to your financial advisors and putting your assets in your trust, they may ask you for something called a certification of trust. And that is also in your estate planning binder. It's basically a much shorter document that serves as a a Reader's Digest version of your full estate plan. I'm sorry, of your full living trust. It talks about who made the trust, what's the date of the trust, who are the trustees, what are the powers of the trustees, etc., etc. And some financial institutions may ask you for a copy of this thing called the Certification of Trust. Now, some banks may have their own document, and that's okay. Just go ahead and fill out their document. It doesn't matter to me as long as the asset gets in your trust. So some assets do not go in your living trust. And if you met with me before, you've known that I have a graphic, or at least a drawing, where I show you the two funnels that your assets will generally pass through. One funnel is your living trust, but another funnel that your assets may pass through is the funnel of beneficiaries. So that's why I write here, some assets will pass through a different funnel, usually by way of named beneficiary. So what kind of assets transfer by way of beneficiary? Well, generally speaking, tax-deferred accounts. So IRAs, 401ks, 403bs, pension plans, annuities, things of that nature. Generally tax-deferred accounts. So what you need to do with those is you actually have to call the company that has the IRA and say, hey, listen, company, I'm Joe Smith and I want to find out who my beneficiaries are. And you might be surprised. You might find that you don't have the correct beneficiaries. And so you want to ask them, who is my primary beneficiary and who are my secondary beneficiaries, also sometimes called contingent beneficiaries. So you want to make sure you have backup beneficiaries, because the person that you named might die before you. They might die at the same time. So you want to make sure that you have backups listed. In my opinion, naming people, naming human beings, is usually best when it comes to naming beneficiaries on the beneficiary form. And the reason for that is just a logistical nightmare sometimes to name the trust as the beneficiary. And I would only name the trust as the beneficiary of these kinds of assets if you had significant concerns over the people who are inheriting from you. Otherwise, also if they are minors. But once they are no longer minors, once they are adults and they have good heads on their shoulders, and hopefully you're choosing people who do have good heads on their shoulders, I would go ahead and name the individuals themselves. One question that often comes up is, what if a child dies? So let's say on my IRA, I name my wife as my beneficiary, my primary beneficiary, and I name my two children as my backup beneficiaries or my secondary beneficiaries. The question has to come up, what if one of my children were to pass away? Well, I have two kids, so I would want my one child, let's say my son passed away, I would want his 50% to go to his children. So on the form that you fill out, you got to check off a box that says per stirpes, or you might see a box that says by right of representation, or if you don't see any of these choices, you might want to ask the company, hey, what happens if one of my beneficiaries passes away? And that's especially important if you have grandchildren and you want those grandchildren to get their share. So the company might say, hey, this is what we do. Either we do that or we automatically do it by right of representation. It automatically goes to your grandchildren. You need to ask them those questions and make sure that your form is correct. My office can help you with that if you wish. And on the very bottom here, it talks about naming your trust if you wish. And we've already talked about that. You can actually name your living trust as the beneficiary of these types of assets. But in my opinion, it's generally not the best thing to do unless you have significant concerns about the people that you've named. Your living trust does not need its own tax ID number. Sometimes you'll go to a certain bank and they'll say, hey, oh, what's the tax ID number of your trust? You need to get one. And what you need to tell them is that your trust does not need a tax ID number until you pass away in most cases. It won't need a tax ID number. You use your own Social Security number. So you continue to use your Social Security number. Now, after you pass away, your trust might get its own tax ID number at that point. But all you need to tell them is that you have a revocable living trust and that you do not need your own tax ID number for a revocable living trust. Question, should I put my cars in my trust? This is a very common question that I get during the estate planning signing session. And the clients say, well, do I need to, what about my cars? Generally speaking, I tell you that it's not that necessary. It's more of a hassle than it's worth. You see, the DMV has their own procedure. After you pass away, the DMV has a form. It's a one-page doodad that your heirs will fill out, or your trustee, or whoever is going to be handling your estate. And they fill this out, and they are able to obtain control or custody of the car. If you buy a new car, you might want to go ahead and put it in the name of the trust to begin with. And again, it's a little bit of a hassle, but it's a nice thing to do. It makes life a little bit easier for your trustees. But unless you have a $100,000, $200,000 car, you generally don't have to worry about it. Adding your trust as an additional insured to your home insurance. Now, this is kind of important. If you get when you get an estate plan, you want to check with your broker for your home insurance about adding your home as an additional insured. Adding your living trust as an additional insured to your homeowner's insurance policy. So if you have a homeowner's insurance policy, you just call your company and say, do I need to add my living trust as an additional insured? In most cases, the answer will be no, you don't have to. But you might want to check nevertheless. It's just a little precautionary measure. And it generally will cost you nothing to do that. They just want to make sure that they're aware that you have a living trust. The next question is, what if I want to make changes to my living trust or other documents? Please note there are formalities to making these changes. Do not make changes by hand and in the margins. I've seen people do this. They cross things out, they initial, they date, they have little arrows going every which way in the margins. They have written things down, scratched things out. Please don't do that. That is going to create a mess and probably cause more confusion than necessary. There are formalities to amending your living trust, to amending your documents. So just go ahead and come to my office and ask for the amendment, or go to another competent attorney. The point is that I don't want you scribbling all over your estate plan. Sometimes you'll receive something in the mail called a declaration of homestead, and you'll get this in the mail later on. This is something you'll get in the mail after you sign your documents. It protects a portion of your home's equity from creditors and judgment, but it doesn't protect your home from a mortgage company if you default. So the truth of the matter is, this is probably not necessary unless you think you're going to be in trouble with creditors. If you imagine that you've got all kinds of people knocking on your door going to ask you for money and you're going to have all these judgments against you, then I would go ahead and file this thing called Declaration of Homestead. Otherwise, if you don't pay your mortgage payment, they're just going to come and take your house. So it's somewhat helpful, and it can actually even be filed during a lawsuit. So let's say somebody's suing you for lots of money. You can go ahead and file the Declaration of Homestead even at that time. But the point is, unless you really expect a lot of creditors to be knocking at your door and trying to get money from you, I wouldn't bother with this. It's relatively antiquated. I would say do it if you have time. It's fine. It certainly doesn't hurt. What about life insurance is another question that I get. What about life insurance? So, in most cases, I like you to name your living trust as the beneficiary if you want your trust to govern the distribution of the life insurance money. So, for example, my life insurance money is payable to the Mansour Family Trust. I don't have it payable to my children. They're too young. They're going to probably mismanage the money. They may be in the influence of others. I would much rather that money be payable to the trust and protected for them. Also, I want my trust to govern who gets what and how they get it. So how do you do that? You have to call the life insurance company and ask them for a beneficiary designation form, just like you did with the IRAs. Beneficiary designation form. And you can name anybody you want. You can say, my life insurance shall go to my wife. My life insurance shall go to my cousin Sal, to my brother Richard. Whatever you want to do. You can name anybody you want. But remember, minors should not be the beneficiaries of your life insurance policy. I would not advise that because, first of all, they're too young. They're not going to be able to get their hands on the money. And then at 18, most companies will just give them access to all the money, and that's probably not what you have in mind either. So once again, my usual default is to tell the clients to name their living trust as the beneficiary of their life insurance policies. The next question is, where should I keep my binder? I have clients taking their binder and putting it in a very safe place, like their safe deposit box at the bank or in a fireproof safe at home with a combination lock. And I tell them that's really nice and that's certainly secure, but nobody can get into it. And if nobody can get to your estate plan, what good is it if they can't find your toolbox? So I tell clients, look, keep it in a safe place and make sure that the people that you've named in your documents know where your estate planning binder is. It doesn't do you any good to hide the binder, to keep it a secret. I'm not sure why some people do that, but when your team needs that toolbox, they're going to want to know where it is. So make sure that your team, the people that you've named, know where your binder is. Also, at our office, we will have a copy of your trust, which is nice and everything, but generally speaking, the original documents are the best things to have. What should I do with my advanced healthcare directive is another question. Well, your advanced healthcare directive, as you may recall, helps those you've named make healthcare decisions for you. And not just pull the plug. This is about being your advocate, making sure that you're getting the right care, having access to medical records, etc. So what might be a good idea is to give a copy to your named agents. Give it to them, put them in an envelope and say, here, put this in your glove compartment. If you need it, it's there in case you need to run to the hospital. The agent will have your healthcare directive in their glove compartment. In the alternative, simply tell them where the binder is, just like we talked about earlier. If you're very ill, you may want to consider putting a copy of your healthcare directive on your fridge or taped to the back of your front door, the inside of your front door to your home, because some emergency personnel are trained to look at those locations if they come to your house. And finally, if you have a regular doctor or a hospital that you're 90% certain you're going to go to, or they already have a file on you, you may want to send them your healthcare directive and just ask them to keep it in your file. So that would be another good thing to do. At the very least, folks, you got to tell your family and your friends where your binder is, because that's where your healthcare directive is going to be. At the very least, that's what they should know. Now, after somebody dies, there are things to be done, but not right away. I get clients sometimes calling me on the way to the funeral saying, hey, what do I need to do? Shouldn't I be doing this? Or I'm closing these accounts. I'm like, look, there are rarely any emergencies. What you should be doing now is grieving for your loved one. Call me in a few weeks and we'll sit down and we'll create a plan. But there's rarely any emergencies. The truth is, at the very least, you can order death certificates. That much you can do. But generally speaking, doing much more than that in the very first 48 hours is probably not a very good idea. Professional guidance is a good idea. You got to meet with the lawyer, got to meet with the tax professional. Make sure you are handling the estate properly. Do not start distributing assets right away. You may actually do more harm than good. Remember, if you start distributing assets to people and then later you find out, oops, I wasn't supposed to do that, that was supposed to go to so-and-so, or that was supposed to be split up among the following people, and in the meantime you gave it away to somebody, you got yourself a problem now. Some married couples also have trusts that require a split of the assets, so you got to be very careful when you're handling a living trust. You can't just treat it as one document. Sometimes you may be dealing with a document that called for a split of the assets upon the first spouse's death, in which case you may have two trusts that you're not even aware of that you have to administer. So just be very careful. At the very least, a consultation is prudent with a lawyer. So I always tell my clients to let their trustees know about my existence, because if they need some help, they can always come to my office for a consultation. Also, in the very front of your binder, in the overview section, as I mentioned earlier, there's a lot of instructions there as well. I'm the successor trustee. What should I be doing? Okay, now here is where your successor trustee takes over. Now, like I said earlier, check the binder for a detailed checklist of things to do after somebody dies. Near the back of the overview section is that step-by-step instruction. Check out other videos on my website that might be helpful. I have a whole bunch on the videos section of the website. Just go ahead and check there. See if you find any other helpful videos. Also, this page of the website, as time goes on, will be featuring new videos as I'm able to create them. And of course, a consultation with a lawyer is a good idea. And I'm not just saying this because I'm a lawyer. I'm just saying this because, look, if I want dental work to be done, I go to the dentist. If I want somebody to fix my jacket, my suit jacket, I take it to the tailor. I don't mess around. I just go to somebody who knows what they're talking about. So a consultation at the very least is a good idea. Again, my name is Robert Mansour, and I want to thank you for watching this video of called I Have an Estate Plan, Now What? And I hope you found it to be very helpful. You can always call my office for more information or to set up your own estate plan at 661-414-7100. And you can visit my website, mansourlaw.com, for more information. And again, please feel free to contact me if I can be of further assistance. Take care.